Mr. Elwell, it looks like, are there some of the motions we have not addressed, maybe the first item?
Your Honor, respectfully, just on that last issue, just many apologies, but just in the interest of efficiency, given the number of discovery disputes we already had in this case, I'm just hoping if Your Honor could just indicate to the prosecution, to the extent they're amending the witness list, or which I imagine they will, in light of Your Honor's ruling on Shane Sutton's testimony, we have cross-examination and opening statements coming up in the next couple days. We have to have an understanding what theory of value, what witness will be testifying about value. So I just request Your Honor instruct the prosecution give us whatever witness list that will be amended and any documents or reports from that witness by the end of the day today, so we can start preparing our defense.
Is that all? Anything new?
No other. The people would not be presenting any. The other witness is not current. That hasn't been previously listed in our witness list.
Right. The difference with Mr. Sutton's not going to testify in your case in chief, but you're still going to have Mr. The supervisor or the
Jimenez.
Mr. Jimenez, right? Well, it's up to you. I'm not telling you how to, but you're not going to have any.
I'll be discussing this with my co-counsel of how to proceed in light of the court's ruling, but again, the court just requesting that my objection to your ruling is noted for the record.
Objections noted.
Thank you, Your Honor.
And I would just note, Your Honor, prior to this date, Mr. Atwell did indicate to us that Mr. Jimenez was not testifying. I don't recall if the witness list has been amended yet, but to remove Mr. Jimenez. But if it is going to be amended to add him, I just like disclosure of that before it happens. And I think we've received notice that it was possibly he would testify because it was in your February 3rd disclosures. So I don't think it's the same prejudice adding him, but I'd just like to know if he's actually testifying.
Again, I'll be discussing with my co-counsel how we're proceeding in light of the court's ruling.
All right, disclose it as soon as you can.
We'll do so as soon as I can.
Okay.
Thank you.
All right, let's go to people's motions eliminating. Let's see. First item, Mr. Atwell, I believe you moved to exclude photographs and videos that have been disclosed that were taken by Mrs. Santurio or Ms. Paul?
No, Your Honor. I'm moving to exclude photo.
Well, I'm sorry, not taken by them, but they were disclosed.
Yes.
In their possession that was disclosed to you.
Disclosed by the defense, correct.
Right, okay. All right, and these were evidence that depicted the manner in which these animals were treated or they were raised, is that correct?
No, Your Honor, a few of the videos do involve the chickens. After this incident, most of the videos and the photographs, as people are trying to move to exclude, are videos and photos from within the foster farm, or allegedly taken within the foster farm facility. Not in the truck, not the YouTube video, but
Right.
From within in some foster farm facility. I believe the defense is alleging it's a Livingston one, but again, not.
Okay. All right. Mr. Shaw, how are these photos and videos relevant?
Your Honor, I think the motion really is kind of two separate motions. One is, and tell me if I'm wrong about this, it's one motion is to exclude the audio and the text on any videos, correct? On the grounds that this is hearsay evidence. And that's related to all the videos. You know, the prosecution has moved to exclude all audio and text of these videos on hearsay grounds. And separate motion to exclude evidence of video that doesn't relate to the specific chickens and specific incident on September 20th. Is that correct? Summary of your motion? I think that's how I understood your motion. It was kind of two motions in one.
Yes, Your Honor.
Okay, so let me talk about the first.
We don't even go to hearsay unless we establish relevance.
Of course.
Yes.
Yeah. So why don't I establish relevance first? The videos relating to the specific chickens at issue, I don't think there's a dispute about those videos. So I think
people have a separate relevance issue as
For sure.
the
The timeliness of them.
Yeah, well, the videos of the chickens were taken after the incident, and like the relevance of any, they were taken after the incident, so they wouldn't be relevant to any good faith of defendants. And prior to that, and any statements within would not be.
Can we just address those videos when we
Okay.
address them? Because I agree that's a separate motion. So we're just talking about videos that, right now, I mean, I'm not saying you don't have an objection to other videos, but right now we're just talking about video that doesn't have to do with the chickens at issue in this case and the incident on September 28, 2020. With respect to those videos, I think the relevance has already been determined by Your Honor's ruling on mistake of law. If there's evidence to show that my client had a good faith belief that under the doctrine of necessity, claim of right, under various defenses, that she was entitled to remove these chickens, and these videos are probative of that question, and I think the testimony you hear in court when we call our witnesses is these videos were crucial. The fact that they saw animals being buried alive, the fact that they saw animals being scalded alive, conscious, into a boiling tank of water, were the reasons they felt entitled to remove these chickens from a slaughter truck who were sick and dying and collapsed on the ground, because they thought these chickens would also end up buried alive or boiled alive. And the fact that there exists video footage showing that their belief was a good faith belief is probative of their mental state. So it's not hearsay, because it's not about the truth of the matter asserted, it's about their mental state when they watch the video. And it's relevant because to the extent we're trying to determine whether my client had a good faith belief that there was animal cruelty that needed to be stopped, we kind of have to see the animal cruelty they looked at, right? Because for all the jury knows, they could be making this up. It's a completely fictitious excuse for trying to steal some chickens. But if they can actually see the video evidence of the conditions in the slaughterhouse and the trucks before the woman took these actions, then the jury might conclude, okay, I believe their belief was good faith. Even if it was wrong, there's actually some evidence that would justify their good faith belief that they had a claim of right, they had a right under the doctrine of necessity to give aid to these animals. So I think relevance is very clear, because to the extent this video footage is necessary, and I think it is necessary, to show what was on these women's minds on September 28, 2021, it has to come in. So that's with respect to the, and then I'll separately argue about the text and the audio, because I think the text and audio should also be included, but I think that's a hearsay objection that I can argue. Please go ahead.
Thank you. Your Honor, I'll just briefly add, the videos that we seek to introduce were viewed by Ms. Santurio and Ms. Paul before the incident. It informed their knowledge and their intent. Certainly their intent and their good faith belief on the applicability of a legal opinion they had reviewed is informed by what they actually saw inside. So the videos further corroborate what they believed was happening, what would have happened and what would not have happened to those birds had they gone into the slaughterhouse. Particularly, they would have been subjected to animal cruelty. They wouldn't have gotten appropriate care for what appeared to them to be great distress. And just based on sort of the limited offer of proof that the prosecution has been giving to us throughout the last few days, certainly the evidence of the videos would go to contradict some of the claims from foster farms about how their animals are cared for and things of that nature. Obviously, by the time we get to our video, the prosecution would have already rested their case. So frankly, I kind of feel like this objection is a little premature. We have a good faith belief that this evidence is relevant, particularly with these specific intent defenses, and we should be entitled to open on it. And if there's an objection at the time, the prosecution can certainly make it, but I'm not entirely sure that now is the appropriate time to address that.
Okay. So, first, again, this goes to animal cruelty. Your Honor, you excluded the defense of necessity. So, it would a claim of right and the claim of right theory is either under a theory of bandit, while mistake of law is based on a theory of that they were told that this is item, that their actions were legal by a law professor, or what was happening. This wasn't what was happening. The videos of what happened in the truck or anything that was apparent on the day of at the time, it's what may, the videos of what they think may have happened. And it, again, and it is here, it is not relevant to their good faith.
Yeah, let's do this. Court's gonna reserve, its ruling on this issue until the people rest.
Also, Your Honor, I'd be objecting to the use of any audio in any of these videos on the basis that I have not been provided any transcripts for any of defense videos was provided, and under the rules of court, any transcript must be provided to me 25 days before trial. I requested, I informed the defense when I handed my transcript for the one video I'm intending to provide that it is required under the
The court would just indicate at this point that counsel, if there are any audio, transcript of the audio statements have to be prepared and presented to counsel, to opposing counsel. Both of you guys would have to agree to that before they are presented to the jury.
I'm objecting to that due to the lateness of this. Since again the court of rules specify it has to be 25 days before day of trial, and we're in the middle of jury selection.
Well, it's. I don't know what the defense is going to do, but I'm just saying that if that's what you want to do, you want to be prepared, and the court can make its ruling at that point, whether it's hearsay, whether those things would even come in, whether the evidence of the videos would even come in as relevance, based on relevance and hearsay rules. But I'll reserve judgment at that point. I'm just instructing you at this point, if you're going to, that's what you want to do, you want to be prepared, make sure you have transcripts and have those discovered to the people. Again,
I'll be requesting my objection and noted due to the lateness of this transcript.
The objections, no.
And Your Honor, I would just add, the defense has not actually determined whether the two classes of videos at issue are edited videos with text overlaying them.
Okay.
And I understand the objection there. We've actually also produced unedited versions of those videos that don't have text on them. So I think it's not just the audio, but also the text on some videos, correct, in your motion that you're objecting to?
Under hearsay grounds.
Yes. So we have provided versions of the video that do not have text on them to the prosecution already. We have not determined whether we actually are even going to try to play the audio yet. I understand the objection on hearsay grounds. We will try and argue an exception, and we will certainly have transcripts available to the extent you're playing audio. Okay.
All right.
And people are also objecting to videos taken involving the two chickens at issue after the events under different relevance ground, that these videos were taken of the chickens after the event, and they, since these are temporally after the event, they wouldn't go to good faithfully beef under or any of the defense and theories.
Okay. I'll go ahead and again reserve ruling on that until people rest. After people rest.
Understood, Your Honor.
Okay.
People's 3, 4, 5, and 6 all have been effectively resolved, all based on the court's rulings on defense motions.
Good. 7 is granted, and is there any reason why that shouldn't be granted?
Your Honor, we have no objection to that motion being granted. We disclosed those documents only because under 1054.3, we have a requirement to disclose any materials that are the basis for an expert forming an opinion.
Sure.
These are documents our expert gave us. He just said, these are some of the things I looked at. So I don't imagine the newspaper articles about the incident on September 28th are relevant or admissible. They're just documents our expert reviewed because she was looking at whatever evidence she could.
Sure.
She handed over a file to us, we handed over to
All
her.
right. So 7 is granted. 8, against, these are articles regarding diseased chickens. Not diseased chickens, but diseases in chickens, right?
Yeah, Your Honor,
Yeah,
this
those-
is
yeah, would be-
kind of classic background kind of evidence that our expert is using under
Sure.
Sanchez, so I don't imagine we are admitting these as evidence in the case.
Well, it
but
would
our
be
expert-
admissible. The
Yeah.
evidence, assuming there's sufficient foundation laid, the expert can testify to the basis
Exactly.
of his opinion, even if
Yeah.
those bases are hearsay,
But
relying on hearsay, sure.
That's correct, and so we're not actually expecting necessarily to admit these exhibits, they were just provided to the prosecution as part of our disclosure requirements, because our expert did review these articles in
Okay.
preparation for her testimony.
All right. And then number 9, we have a number of character evidence, character witness testimony, and the people requesting that they be excluded.
Yes, Your Honor. Character evidence is usually, inadmissible. Defense may present evidence of contrary character or attributes, which people are not alleging in that defendant did not act within in a belief that they needed to save these animals. But, and so positive traits that they would act, that the defendants acted in accordance with that, with any traits, it would not be irrelevant. And also the listed, in the witness list is provided by defense, and that the reputation that they would be providing is history of volunteer work for the homeless, or reputation of Mrs. Alexandra within the acting community. These are not relevant in character traits in a charge of petty theft.
Your Honor, respectfully, I think you misstated the use of the character evidence that we're attempting to introduce. What we're hoping to introduce is Ms. Paul's reputation within the community of people advocating for the homeless for truthfulness and integrity. And there's clear case law, and I'm quoting here, chapter and verse, People versus Taylor, 180 Calat 3D 6222, and this is a direct quote. By constitutional command, we hold evidence of defendant's reputation for truth and veracity was admissible at trial for the purpose of proving the truthfulness of his testimony, notwithstanding that the prosecution did not first introduce evidence impeaching defendant's character for truth and veracity. Furthermore, Evidence Code 1102 makes very clear that in a criminal action, there is an exception to the general character evidence rule when a defendant is offering character evidence to prove his conduct in conformity with such character or trait of character that's relevant to the trial. Ms. Paul's veracity and truthfulness is inevitably going to be an issue, especially if she testifies, and we haven't made that election that we don't have to, but if she testifies, her truthfulness is certainly going to be an issue. And secondarily, because the prosecution is alleging that Ms. Paul took something of value, no matter how slight, her reputation for generosity and for giving, not taking, is relevant. So I would say there are two character attributes directly at issue in this case. Under People versus Taylor in 1102, and the ballot initiative passed in California in, I think, 1980s, indicating that relevant evidence in a criminal trial should not be excluded. We're 100% entitled to any evidence regarding her truthfulness and integrity and her veracity. But secondarily, given that the charge against her is that she takes things of value, if we can show actually she doesn't take things of value, she actually gives things of value, that is directly relevant. So for both those reasons, we think reputation within the community, personal opinion, and specific instances of conduct all are admissible for the purpose of showing Ms. Paul's good character. She's a deeply and profoundly good human being. Her characteristics are relevant to the elements that the state has to prove beyond a reasonable doubt.
Okay. Mr. Arrow?
My co-counsel, Travis Colby is here.
Okay.
Your Honor, if the court is inquiring about whether or not character witnesses are relevant in this case, the answer is under 351 and 352, they are not relevant and they should not be admitted into this case. there is no practical dispute as to certain facts in this case, as to what had occurred in this case physically and factually. I understand there may be some disputes as to motive, there may be some disputes as to underlying causes and backgrounds, but in terms of character witnesses can only be offered by the defendant under Evidence Code 1102 to provide a reputation for certain character and conduct in conformity with that character, but a prerequisite to that is substantial evidence that somebody is being accused of acting outside of the character. We don't have that here. So under 1102, character evidence should, in general, be denied by this court.
Okay.
And Your Honor, I just come back to People v. Taylor, which says very clearly that evidence of a defendant's reputation for truth is admissible, notwithstanding that the prosecution did not first introduce evidence impeaching defendant's character.
What's the site for People v.
People
Taylor?
v. Taylor is 180 Cal App 3D 622.
Okay.
And this is effectively repealing, and this is the case, and I think the Supreme Court in California has held this too, repealing the prior provisions of the evidence code saying this sort of character evidence was only admissible when you're first impeached. This is 786 through 790 of the evidence code have all been repealed by the ballot initiative and changed the California Constitution that made relevant evidence admissible in a criminal procedure. So the People v. Taylor is controlling on this. It says very clearly we're allowed to introduce this evidence even if it has not been first attacked by the prosecution.
Judge, I would just supplement, I think it's obvious in this case a huge contested issue is intent, and I would say above anything else, character evidence program of intent and sincerity and good faith belief. So I think its probative value is really maximal than, say, a general intent crime.
Well, and I would assume these witnesses are not going to testify until the defense case in chief.
Correct.
So I'm going to take the argument under submission on regarding number 9 in reserve.
And Your Honor, with regard to it being under submission, we ask the court issue a ruling prior to opening statements so that it's clear what can be addressed for opening statements in terms of what counsel expects the evidence to show.
Well, you know, if there are issues that the court took under submission that had not been ruled upon, and you're not discussed those in open statement.
As an alternative objection to 3 of the character witnesses, Daphne Zuniga, Daryl, Hannah, and Dotsie Bosch, I apologize for butchering the pronunciation, are all 3 public figures, and the people who are concerned if they're allowed to testify, it would lead to undue consumption of time because all 4 or the Ms. Alexandra Paul has 4 character witnesses, and 3 of the since 2 of these witnesses are well-known actresses, and 1 is a silver medaling Olympic athlete. Their opinion, I believe, is overly prejudicial for the limited and probative value of their testimony on character.
Okay. I'll try to issue my ruling as soon as I can.
And Your Honor, just on that point, on the 352 issue, we're not expecting these character witnesses to testify for hours. I imagine, depending on cross-examination, these could be done in 5 minutes, but I do think the fact that they have some credibility, the fact that they have extensive experience with my client, and the fact that they can testify about attributes that are relevant to the testimony she may offer and other witnesses may offer in this case about her integrity, her veracity, her generosity. These are attributes that are probative of the questions at issue. We're not going to take a lot of time on them. And the very fact that these are public figures makes their testimony even more probative in many ways. So it's not clear to me what the legal grounds are for excluding someone from testifying simply because they're a public figure.
So, Your Honor, counsel said something I think is very important to latch on to. Generosity. He wants to produce these character witnesses to, in part, establish generosity on behalf of the defendants. What relevance under 350 and 351 would that have at all to the facts at issue in this case? And the answer to that is quite simply none. So when you look at 350 and 351, they would again be inadmissible, even under 1102. And under 352, witnesses to speak to a person's generosity, especially ones with such notoriety as named by defense counsel, would in fact serve no other purpose than to mislead the jury from the issues at hand. So I think counsel has actually made our point clearly that being presented for some purpose other than to establish character in conformity with a certain trait that's relevant to this case. They haven't, it's going to be a sideshow, quite frankly.
All right, that'll be taken under submission. All right, item 10, people's objection, people's motions eliminating number 10 is the testimony regarding the veterinarian.
Yes, Your Honor.
Okay, Ms. Yamada?
Shimada's, yeah, separate witness.
Yeah.
So this is actually kind of two motions.
Yeah, two motions, and Your Honor, one for Mrs. Is Yamada's testimony regarding the condition of the chickens after the events, and additionally the veterinarian reports. People feel, number one, the veterinarian report is hearsay that does not constitute a business record because this was effectively an autopsy of a chicken and made in contemplation of either a criminal action and against the defendants or a lawsuit against Foster Farms. This was not a record or made in anticipation, that was in some regular course of business as required for it to constitute a business record. Additionally, people are concerned on the foundation of the contents of the records, or it's the defense has not provided any documents or statements regarding that this chicken examined 10 days after the theft was the same chicken that the defendants took. If this was a autopsy of a human body and my office presented and said no chain of custody indicating that the corpse examined was the same corpse of the victim, it would likely be excluded on that grounds. I specifically requested, it quotes, any and all evidence or documentation regarding chain of custody by Catherine D. Watson and on October 7th was the same chicken taken from Foster Farm on September 28, 2021, and I sent that email on February 10th to the defense, and then they did not provide any such document. So we do not have any way to establish, there's no foundation establishing the chicken examined was the same chicken.
Okay.
Your Honor, if I understand the prosecution's argument, they have two fundamental objections. One is that an autopsy of a chicken and necropsy is hearsay. And the second is some chain of custody argument. So I'll address each in turn. It's fitting that the prosecution call this an autopsy because autopsies are business records. People versus Beeler, 9 Cal 4th, 953, found an autopsy was admissible as a business record with proper foundation. That was abrogated on confrontation grounds irrelevant to this particular issue, but it's commonly held an autopsy is in fact a business record, and a necropsy is fundamentally the same as an autopsy. Next, the prosecution presents some arguments.
A necropsy is a autopsy report of a chicken or an animal?
Yes.
Okay.
And the prosecution next presents some argument that these were in contemplation of litigation. Charges in this case I don't think were filed until months later. So obviously when the autopsy was done, which was less than 10 days after the date of offense, that's just factually incorrect. There were no charges, and the prosecution speculatively throws out they were going to file a lawsuit. I don't know where that came from because there's been no indication of that, and no lawsuit was filed. So this argument that it was in contemplation of legal proceeding is just speculative and also just inapplicable because...
Well, what would be the relevance of these reports?
The relevance of the necropsy of one of the birds taken, I think has a few important components. One, it's relevant to the expert testimony as Dr. Rosenberg, the vet, relies on them in assessing the conditions of the chickens and their value. And two, the prosecution, at least through their pleadings, have attacked the ability of the defendants to make a judgment on the condition of the chickens when they removed them from the truck. The fact that the chicken, Ethan, was so grievously ill that he passed away and had a litany of ailments is, I think, objectively corroborative of their observations at the time. So it's highly relevant and highly corroborates what they perceived. And I think that's relevant to the specific intent nature as well as the mistake of law defense. And I think that's the main objective evidence that we have in this case with respect to the chicken's condition, which I understand to be highly disputed by the prosecution.
Well, it's relevant to specific intent at the time of the crime, but if these were 10 days later, how would they be relevant to forming their specific intent at the time of the crime?
Well, Judge, it was I think it's 4 or 7 days later. It was received
3 to 4 days later.
Yeah, and I don't know where the 10 days later came from, but regardless, if I say a chicken looked ill, certainly a doctor's report saying, yeah, you're right, the chicken is ill, corroborates my belief in my specific intent. That is sort of necessary evidence, especially if the prosecution is going to challenge their ability to make that determination. And is perhaps the best evidence of a critical issue in this case, which is the conditions of the birds. The birds that Ethan passed away shortly after, passed away with a litany of really grievous ailments that certainly had to have pre-existed before being rescued from that truck. And it's direct evidence that Ms. Santurio's belief and observations was in fact correct.
Well, but it goes to the issue of what? It goes to the issue of value?
It's relevant to, I think, value, corroboration of her specific intent. It's relevant to her credibility in making that determination that these animals appeared sick. And so I think it's relevant to, I think, the two main issues in this case, intent and value.
So, Your Honor, specifically.
Let me just add, because on behalf of my client,
Apologize.
because we're both I'm joining in obviously opposition to this motion, that one of our witnesses is Dr. Tristan Rosenberg, who will testify to the condition of the animals. And one of the documents she looked at, this is a case-specific fact under Sanchez, was 100% this necropsy. And she will testify that it is certain that the conditions found in this necropsy existed in the chicken at the time that they were rescued in September 28, 2021. Because the necropsy indicates the birds died between 3 and 4 days after September 28th. October 2nd is the day the birds died. October 4th is the day the necropsy begins. And the date that Mr. Atwell is referring to is the date the report is issued, because there's all these tests they do. They do pathology, they do bacterial samples, and all these other things. And then it's 10 days after that they issue the actual report. But the date of the death of the animals is between 3 to 4 days. And we need this evidence to show the condition of the animals. Were these animals diseased? Did they have value? Were they a liability to the company? Were they even legally allowed to be on that truck? All these issues can only be interrogated if we have the most definitive and objective proof. And I would just agree with counsel for Ms. Santurio that it is preposterous to think that these records were produced in anticipation of litigation. These are records from October of 2021. The complaint wasn't filed until April of 2022, almost 6 months later. So there's no suggestion at all that either of these women, they thought that they had done something good and legal and right. The notion that they're prepared for litigation by performing a necropsy on an animal, that they were concerned that the other animal could die of the same disease, is just not supported by any evidence in this case whatsoever. These are not documents prepared in anticipation of litigation. These are standard practices that my client will testify happens whenever any animal dies. You take them in and figure out how they died to ensure other animals in your care, even human beings in your care, might not be susceptible to disease. And what these documents will show is not only were these chickens very, very seriously diseased with multiple pathogenic infectious ailments, but they had diseases that were dangerous to human beings. And that is a serious concern for a company that cares about the value of animals. If they had Enterococcus, E. coli, and other zoonotic diseases that infect people eating these chickens, that is a material fact to determine how much value these chickens actually had to Foster Farms on September 28, 2021.
Your Honor, counsel's mixing arguments here, and they're playing one argument against the other to benefit. What really boils down to here, first with specific intent. Specific intent in this case is, did the defendants intend to take the chickens? That doesn't matter what their condition is. If you went out in the parking lot and you looked at my car and you saw it had a flat tire and it was dirty, you wouldn't have a right to take that car because you felt it was in an unsafe condition for the road as a standard citizen. So that's essentially what we're dealing with here. The issue of specific intent is not something for which this would be relevant. Now, as to the issue of value, counsel says that these chickens were diseased. this is where, it doesn't matter if it's 3, 4, 7, 10 days after. The fact is that wasn't ascertained until after the acts constituting the crime had occurred. So for purposes of value, a report that the chickens, after we took the chickens, matter of fact, it does look like they were sick. That's not a defense, and that's not relevant to this case. Timing is the key here. Was it something that was relevant before they took the chickens? And the answer is no. That's why the dating, whether it's 3, 4, 7, or 10 days later, doesn't matter. It's still irrelevant. So it should be excluded under 351 and also under 352 for obvious reasons of delay of the court case.
And Your Honor, just briefly, new counsel wasn't privy to the court's ruling on mistake of law, which does broaden the specific intent aspect quite substantially. And obviously, what they believed at the time is analogous as the busted car outside situation. But I mean, when we look at like probative evidence, the prosecution is going to challenge the defendant's belief that these animals were sick. Does a subsequent necropsy make it more or less probative, more or less correct, that their belief was correct? And the obvious answer is yes. If I think I have COVID, certainly the best evidence that I do have, I don't have COVID, that I do have COVID would in fact be the subsequent test that I do. That would make it more or less relevant that my initial perception was correct. So, I mean, I think it's rather straightforward. This is the best evidence, and this should be admitted. And with respect to undue waste of time, the prosecution had stipulated to the foundational testimony from the custodian records from UC Davis. So we're just simply introducing this. We don't even need to call a witness.
And Your Honor, I would just add, the California instruction makes very clear the property taken must have some intrinsic value, however slight. My client did think these animals had no value when she took them. She did think these animals were sick. But even if she did, even if she thought this was the most valuable chicken in the world, worth $1 billion, if the chicken actually didn't have value, then the state can't prove beyond a reasonable doubt the elements it has to prove. Right? So if someone delusionally thinks a piece of lint on a table is worth $1 billion and they take that piece of lint, they're not liable for grand theft. They're not liable for theft at all unless that lint has some value. This is an objective test based on the actual value of the property. The necropsy is probably the best, probably the most crucial evidence of the objective value of the property. So to the extent that objective value of the property is at issue in this case, and it is by the instruction very clearly, the property must have some value, however slight, it is admissible evidence.
It's, well, Mr.
Although- Although again, on the case law regarding values, that even a piece of paper or on a otherwise illegal check was enough intrinsic value. It doesn't necessarily need to prove that evidence was any specific value, but could be, as long as that evidence had some intrinsic value, it can be subject to theft. But again, this was something outside the defendant's knowledge when they took chickens. They may have suspected it, and based on their observations, that it was sick, but this was going beyond and again, and this is not this report which I do not believe Ms. Watson has been listed as a witness in any of the defenses is witness lists. It does not count, unless I'm mistaken on that.
No, it's a
She's not
business
the
record.
she's not the,
Custodian's gonna
she's
issue
not the
it.
custodian of records.
Right.
She's not the one who maintains these records. We
But-
subpoenaed the person who maintains these records is UC Davis. UC Davis indicated that, I don't recall her name, the custodian of records is the
Your
person
Honor,
who's been subpoenaed.
The
But-
prosecution's correct. We're not calling the vet, and that's because the case law is clear that a record such as this would be in fact a business record. And to my knowledge, the prosecution has not sought to bring in that witness themselves, which they certainly have subpoena power to do.
And if I could just say, Mr. Atwell has misstated the case law on a lottery ticket. The case law is not that a lottery ticket or a piece of paper does constitute value. The case law is that a jury is entitled to rule that a piece of paper or an empty cigarette carton is sufficient value. So we're of the same opinion as the cases, which is it's a jury question. And there's no question that a jury that looks at a necropsy and says, this chicken is very, very sick and has diseases that I can get sick from, that is gonna affect the jury's perception of the value of the chickens at issue, and therefore we're entitled to it, Your Honor.
So, Your Honor, this also has some issues. It does open the door. My understanding is the court has excluded a people's witness who would testify as to value from the company owner, the company itself. This, again, creates an issue, even if there is some tangential relevance, which we believe there is not. Counsel's analogy of COVID was a good one. If I look at defense counsel and I say, I think you have COVID, so I'm going to lock you in a room, I don't have a right to do that just because I think your condition is poor. Same thing here. So what this boils down to is the question of value. I agree that's the area that we need to argue this about, and I'll agree with counsel on that. However, in terms of value, some intrinsic value, the people do have to prove that element, as the court has said. So this would, if admitted, definitely open the door to employees and executives of Foster Farms testifying as to the value that the chicken did have in whatever state it may be in.
I did indicate that earlier.
Right.
Yeah, that it would open the door. I would just add that the defense arguing that this is the chickens because they're diseased, they have no value. I think it cuts against the defense argument that it has no value because the defense went through extraordinary length to save these chickens. So they have, that in itself can be intrinsic value.
And Your Honor, I agree with the court. I believe that from a common sense perspective, looking at the acts of the defendants coupled with the manner in which the chickens were transported and a number of other factors make it beyond any reasonable interpretation of the evidence that they did in fact have value. Now, I also agree with defense counsel that that may in fact be an issue for the jury. While I don't believe it to be a significant one, that's the one issue that this would concern, I believe.
Right, well, yeah, the other concern the court has is to make sure it's not an undue consumption of time, but the report is just gonna be presented, right?
Yeah, it's
Okay.
gonna be presented and discussed by an expert witness. Probably a couple defense witnesses will refer to it. I think the jury should be entitled to see it to show that it's actually a business record, that it actually was definitively determined by a separate vet, not a vet retained by the defendants, or not a vet who works with the defendants on a regular basis, but a world-renowned livestock vet that normally works for the industry. So these chickens were very diseased. And
The court, I'm gonna deny the people's objection, overrule people's objection, because I think it's relevant to the issue of value.
All right, is this court ruling being open the door or to Mr. Sutton's testimony on the issue of value?
I had so indicated earlier that I would open the door, but I don't know what they're gonna do.
Understood.
Your Honor, and I would just, again, state that the necropsy is about the medical condition of the birds. An accountant expert is a completely different set of testimony that we're not prepared for.
Well,
It doesn't
you're gonna
relate at
argue
all.
that because it's disease, it has no value.
Mhm.
And that opens the door to the people to argue, even though it's disease, it has some value, and this is how our company values it. So that does open the door. And, unless you argue it doesn't have no bearing on value, then what's the relevance? All right, let's go to letters to elected officials.
Your Honor, the letters of elected officials would only be relevant under a defense of necessity, E for alternate actions, as the court has already barred that defense, and people plead that there is no further relevance of these letters.
The court agrees with that. Anything else, counsel?
Well, Judge, considering that the mistake of law defense tangentially relates to their belief in necessity, certainly, as we had a discussion this morning, the prosecution is going to argue, well, why didn't you do X, Y, and Z? That certainly opens the door. Like, well, we did send letters to why they felt under the facts that they could rely on the advice of counsel because they had sort of exhausted other reasonable alternatives. And this is also another instance in which, I think the only argument with the prosecution is the relevance. They were agreeing to sort of stipulate to the brief foundational testimony of the witness anyway. So it wouldn't take much time, and I think it would be a pretty quick issue, but I do think it's sort of relevant to whether or not they had a good faith belief that because of applying the facts as I saw them to the advice that I was aware of and it was given, that necessity sort of applies because I don't have any other options, because we've tried all these things. And I also think it's important for the jury to understand the context of the entire situation as part of sort of the fact-finding, truth-finding process in this trial.
Sure.
Again, the court has already ruled that necessity is not a defense, so these statements no relevance at this juncture and find that. Additionally, one of the exhibits, defense exhibit 1 was dated over a year after the incidents.
All right, the court's going to grant the motion to exclude letters to government and elected officials as hearsay. Those would be relevant to the issue of, they would be hearsay, but they will also be relevant to the issue of necessity, which the court had already indicated that necessity is, there's insufficient evidence at this point for that defense, so that's excluded. 12, the people request eventual death. Okay, the testimony regarding the death of the chicken.
I'm going to jump in. I think that might be a factual mistake. The chicken named Jax did not pass away, so I think that just might have been a misunderstanding.
Okay.
That may have been misheard by the people, both of us.
So withdraw that motion.
Motion withdrawn.
Number 12 is drawn.
Although if the people request if Jax dies over the course of this, no, the chicken labeled Jax dies over the course of this court hearing. People would object to it.
Okay, we'll wait and see. All right, 13, judicial notice of certain code sections of Food and Ag. Do you intend, want to bring those in?
Yes, required under 452, but 451. But in essence, in the code would say that animals given certain animals quarantined by the for veterinarian and order or to be destroyed due to sickness is the owner of that animal is entitled to compensation. So that would be, since value is being put at issue, that would, and the health of the chicken be at issue, this would be an alternative in theory of value even if the chickens are sick, because they could have been in order or to be quarantined and disposed of by the California veterinarian, and under the law, the foster farms would have been required to receive compensation under that law.
By whom? By government? By the government?
By the state of California, yes.
State of California will pay if foster farms if their own chicken were diseased?
If they were ordered to be destroyed by the California veterinarian due to disease.
Due to disease. Okay. Well, is there any such order in this case that they were ordered to be destroyed?
No, Your Honor. However, the opportunity for such an order to be provided by the California veterinarian was taken away by the defendants, and before the foster farms had a potential opportunity to view it, and it is a compensation under the law in the case of a specific sickness, and so foster farms may have been entitled to compensation under these codes, even if the chickens were too sick to be consumed by humans.
Well, I think it's just speculative because we don't know. I mean,
Yeah,
the
in
defense, yeah, go
terms
ahead.
of speculation, that's the whole point here. So we're talking about not the question of what this specific situation was. When we're talking about value, we're talking about what the potential value was. Defense is going to claim through a vet record that the chicken had no value, which quite frankly is counterintuitive to all the facts, but okay, that's what they're going to claim. And so if they claim that chicken had no value, then a law that says even if a chicken is diseased to the level they claim this one to be, there is still value for the company that possesses it. So with that, under Evidence Code 451, it is highly relevant to that slight value that is all the law requires. If defense counsel is claiming it's valueless because of its illness, we're allowed to say there's laws that say the complete opposite. And the way to introduce that, we can't obviously call the legislature or the governor in themselves to do it, is through Evidence Code 451, which requires the court to take judicial notice of that.
What I mean by speculative is we will assume that there's going to be some kind of condemnation action from state government regarding these two chickens.
Well, the point being is that a chicken, in general terms, who is diseased or does have issues of grave concern, as the defense counsel repeatedly stated, those do have value. And I quite frankly, it's counterintuitive to the arguments here to say these chickens that have no value that they sold. But that said, this highlights the point of if there is any thought that there is no value, we need to be able to show that no, under the law, this is a unique situation.
Even if an animal is condemned, it still has value.
Yes.
Counsel?
I mean, I think the court initially caught the conditional nature of the applicability of regulations. And certainly if this were a case in which the birds were taken off the truck, there's a state vet looking at them, and then they're going to get slaughtered, yeah, that argument might have sway. But the fact of the matter is these birds were minutes away from being slaughtered. No one's checking them. That condition is never going to happen here. So it is highly irrelevant. It's not just the fact if a bird is diseased or injured, they automatically have value. That is not the threshold for state compensation here. The threshold for state compensation is the state vet actually has to get involved and order a private company to do something. And it's the state action forcing a company to do something with their property that would, under basic property rights knowledge, would trigger that compensation. But that's simply not the case here. There's no evidence that the state vet was about to condemn these birds or anything of that nature. This is just a completely irrelevant, speculative, hypothetical condition. And we know the reality is that Foster Farms is not doing the diligence in assessing if those birds are healthy or if those birds are sick, that it would even be caught. So to say that if these conditions for which there is zero evidence for would require value, it's just base speculation, and it's not sufficient to trigger that. I would agree the court can take judicial notice of a regulation. That's not the argument here. The argument is one of relevance. And if they had testimony or evidence to tie this regulation to the actual facts of the case, then that would bolster that.
Well, Your Honor, just on behalf of Ms. Paul, I would just add that the state has not provided any evidence whatsoever that this sort of thing would have happened. In my understanding, this sort of thing only happens when there are mass disease outbreaks across the state of California. If there's any evidence of that at Foster Farms, frankly, all the citizens of California need to hear about this right now. Because it's not just about those two chickens at this point.
Avian flu, they're taking eggs to $10 a carton soon?
Are you saying these chickens had avian flu?
What I'm saying is
That's something that the public has the right to know, if that's true.
This is exactly what's
Counsel,
relevant.
hold on a second. All right, let's tamp it down. Now, okay, so I just understand, defense whole argument is the state is not taking any action despite all these letters and the notices to the state and government agencies, and that's why they took action upon themselves. So at this point, the court, the law is what the law is, but absent some foundation that the conditions of the law are met, then the court's not going to permit any argument with regard to these code sections unless the foundations are met.
Thank you.
So at this point, it's, I should indicate reserve. Okay. All right, and number 14, freedom of information letters. I don't see the relevance of that either.
Yeah. Yeah, the,
Well, let me ask the defense if they have any objection to sustaining that objection.
Surprisingly, Your Honor, the relevance of that is, well, first, it corroborates what's on the video. I would presume that the prosecution will seek to impeach the observations of the video and try to paint this picture that animals are not being mistreated and Foster Farms is doing everything above board. Obviously, the FOIA records shows repeated systemic instances that corroborate what is being seen on those videos. So it's a matter of corroboration. It's a matter of supporting the credibility of evidence that relates to the defendant's state of mind. In terms of the prosecution's argument that there's no hearsay exception, Christian Research Institute versus Almore, 148 Cal App 4th 71 relates to FOIA records. I was surprised to see this objection since I gave the prosecution that case site weeks ago, but that clearly states that if FOIA letters are authenticated as official documents, provided that the attorney representing the proponent declared, or an attorney representing the plaintiffs in that case declared he received the FOIA letters after submitting a written request under FOIA for the documents, and the FOIA letters in response each state they were prepared to the request, and those documents were responsive to that. The court concluded the official record exception to the hearsay rule has been met. So it's not a hearsay issue, I think it's just a relevance issue, and it refutes the claims that we believe the Foster Farms witnesses will present, and it also just corroborates what the defendants were seeing of what was happening inside that slaughterhouse that informed their belief and their specific intent for why they did what they did.
Your Honor, again, these documents were obtained on January 15, 2022, according in documents. Necessity is no longer at issue. It was only what the defenses remaining are regarding in the mental state of the defendants. They didn't have these records at the time. So these documents cannot contribute to that. It doesn't matter, and even by the defense's argument, it does not matter whether or not they're, even if we take the defense is a mistake of law and claim of right as true, as legitimate defenses, is that goes to the mental state they had on September 28, 2021. And documents obtained after that date cannot contribute to that good faith belief, or in any way impact their mental state on September 28, 2021.
Your Honor,
Anything else?
just briefly, I'm going to hark back to the COVID example just to explain how corroboration like this would work. If a defendant doesn't come to court and says, I'm feeling sick, I don't want to come to court, how do you support that belief? Well, you go out and get proof of that. It wouldn't make it less relevant that he went and got proof of how he was feeling after the fact. And that's exactly how corroboration just logically works. And so to the extent that the prosecution seeks to attack the credibility or the defendant's state of mind, knowledge, and belief, subsequent corroboration would refute that. And it's simple. And again, this is another situation where the prosecution had stipulated to that foundational testimony. So we're not talking about lengthy testimony that would introduce that from the attorney that sought these records.
What do these letters indicate? What did they say?
Judge, these were submitted as exhibits yesterday.
Okay.
I think the summary of them indicates repeated violations of the standard practice of avoiding unnecessary animal suffering and non-slaughter-based deaths, and this relates to improper stunning, relates to animals dying on the slaughterhouse floor not because of being slaughtered, of animals not being hung improperly, repeatedly, which is consistent with what the defendants observed in the undercover video.
Gotcha, all right. The court's gonna find that these documents are not relevant. It might be relevant to the issue of necessity, which the court's already indicated that it's not relevant to that, if that defense has not come in, so the court's gonna sustain the objection.
Now, people, and thank you, Your Honor, people withdrawing, motion eliminating number 15.
15,